Hey there, I'm Noel Bagwell. I am the founder of Counsel and Clarity, and I'm also a business lawyer. I provide fractional chief legal officer services to growth stage companies. And I'm here to talk to you today about the Corporate Transparency Act. This is a new regulation from Uncle Sam about how beneficial owners of companies or companies have to report their beneficial owners to the federal government. It's a huge change to not just business formation, but regular reporting requirements to the federal government. Huge, huge change. So, this is what we're going to be talking about. We're going to do a brief intro to the Corporate Transparency Act, understand the beneficial owner information reporting requirement, talk about who needs to report, help you understand what a beneficial owner is and the requirements for BOI reports. And then we'll also discuss timing and compliance, like how long do you have to get in compliance with this new law and regulation, the implications for business, and data protection concerns, about which I'm a little cynical. So just brace for impact on that. So, beginning January 1st, 2024, FinCEN will implement the Corporate Transparency Act's beneficial ownership information reporting provisions, which will definitely bring huge changes to the U.S. financial landscape. So, you should know that the Financial Crimes Enforcement Network, or FinCEN, is a bureau of the U.S. Department of the Treasury, and it has issued a final rule implementing the Corporate Transparency Act's, or CTA's, Beneficial Ownership Information, BOI, reporting provisions. This rule targets tax fraud, terrorism, and money laundering by mandating U.S. formed corporations, limited liability companies, and certain foreign owned entities operating in the U.S. to report information about their beneficial owners to FinCEN. Basically, they want to know who are the people, who are the natural people owning all these companies. You no longer can have the same level of privacy that you had before because we need to protect something, the financial system, I guess, or we need to protect, I guess, things from terrorism and tax fraud and money laundering. They want to know who you are. You can't hide and be private behind a company anymore the way that you used to. Um, that's not as, I guess, terrible as it sounds to a certain degree. There is still some illusion of privacy left, I suppose, um, if you aren't a beneficial owner that's subject to reporting. I don't know. There's not a whole lot of good news about it, really. This is an onerous regulatory requirement. There's no two ways about it. Um, the BOI reporting requirement is a critical component of the CTA. CTA doesn't really work without this. And it's designed to provide vital information to government agencies, especially the Department of Treasury. You know, the same Department of Treasury that has the IRS, that's in charge of making sure that you pay your taxes. So it's designed to provide vital information to government agencies, federal and state officials, and financial institutions. Even outside the Department of the Treasury, there are some implications for the use of the information that's collected. So it requires, the CTA requires reporting companies to file reports with FinCEN identifying their beneficial owners and company applicants. So that's what's up. Who needs to report? Virtually all corporations, all limited liability companies, and all entities of every other kind that have been created by filing a document with a Secretary of State or a similar office under U.S. state or tribal law. No sneaky going to the tribal governments and saying, oh, well, it's not a U.S. state thing. Nope, they included that too. So they're really aggressively closing the loopholes on any kind of corporate privacy. So foreign reporting companies even are those that are formed under the laws of a foreign country but registered to do business in the United States through a similar process. So if you're a foreign company and you're doing business in the US, you also have to disclose who the owners are or face sanctions. So who is it who is it that's getting their information reported to the government? Well, under the rule, a beneficial owner is anyone who directly or indirectly exercises substantial control over a reporting company or owns at least 25% of its ownership interests. The definitions of substantial control and ownership interest are crucial here. And remember, it's or, not and. So, a beneficial owner is anyone who indirectly or directly exercises substantial control over a reporting company or owns at least 25% of its ownership interests. You don't have to meet both of those requirements, just either one of them is enough for you to be a beneficial owner. And the definitions of substantial control and ownership interest as provided in the Act are crucial here as they close loopholes in corporate structuring that previously allowed the obscuring of owners or decision makers, meaning previously allowed you to maintain your privacy. No, no more of that. Government does not like that. Reporting requirements: name, birthday, address, unique ID. It's kind of like when you're applying for a job and you have to, submit your papers. It has to either be like a class A document or one each of a class B and C document or whatever. So, like your passport or maybe your birth certificate plus a copy of your social security card or your driver's license or whatever, right? Like there are all these various things, but you're going to have to report this basic information, including the unique identifying number from an acceptable identification document. So they want to be able to match, you to your papers. This is very, very much a papers, please regulation. So when you're filing BOI reports, reporting companies, and it's the company that has to comply with this, right? But the individuals are going to have to cooperate, and that's going to be not easy all the time. So when filing BOI reports, reporting companies must provide specific information about each beneficial owner, including their name, birth date, address, and unique identifying number from an acceptable identification document, according to FinCEN. The rule takes effect on January 1st, 2024, which means companies that are formed or registered after that date only have 30 days to file. 30 days. So from now on, every time anyone creates a new company in the US or wants to register a foreign entity in the US to do business in the US, they have 30 days from the creation or registration to report. So papers, please, within 30 days. Thankfully, companies that were formed before January 1st, 2024 have a year to comply. So if you're thinking of starting a business, you have 2 days from the date of this recording. Today is Friday, the 29th day of December, 2023, as I record this. So you got a couple of days. If you do create a business within the next couple of days before January 1st, 2024, you're basically buying yourself a year um, to before you have to be in compliance with this regulation. So I don't know. If you've been thinking about it, now's a good time, I guess. Implications for businesses. Businesses must prepare to understand the scope of their reporting obligations. This preparation involves reviewing technical data and operations and ensuring compliance with anti money laundering sanctions and know your customer programs. So, yes, but basically, they're just adding a huge cost to your business. I mean, what else are they going to say? You need to know who is exercising significant control over your business. So that may, for some businesses, be technical, but most small businesses at least know who exercises significant control. And you need to know for sure and for certain who owns, what percentage of ownership interest in your business. And I will tell you, after practicing law for over a decade, that's not always as clear cut as you might like for it to be. I've been in litigation before where that was exactly the heart of the litigation was who owns how much of this business. And you would think that people operating the business would know that, but disagreements crop up from time to time about who owns how much of a business. A lot of times people are like, we don't really worry about it. We just run the thing and we get paid how we agree to get paid. And it's all very fly by the seat of your pants sometimes, alarmingly so. But no more of that. You've got to figure it out because if you don't, you won't be able to be compliant with this regulation. You'll end up getting fined. So I don't know, to the extent that it brings a little more clarity on that basic front, maybe it's not such a bad thing. But this is what really makes the hairs on the back of my neck stand on end. This really concerns me quite a lot. Data protection is a significant aspect of the BOI reporting requirement. The information that's provided to FinCEN is subject ostensibly to strict data protection protocols. I can't imagine it's any more strict than the IRS imposes, right? Because same Department of Treasury. I don't know. I don't know. Is it going to be more stringent? I doubt it. And it says that usage outside of Treasury functions is limited to authorized law enforcement activities. Well, that could be anything. I, does that mean that the FBI or the CIA or whoever has to get, a warrant or has to, get a subpoena or something like that? Like, what are the protocols precisely for other non-treasury law enforcement authorities to come in and get your data about you and your company and all of that from the Department of Treasury and FinCEN? I don't know. I don't know. I haven't been through it with a fine tooth comb. But it is concerning that basically what the public is being told is the government demands you disclose your information or face strict fines and penalties. You just have to trust the government not to allow data leaks and to protect your sensitive information from hackers and other bad actors, including bad actors within the government, people who would abuse their authority and abuse their power. And as we look at, I mean, we're going into an election year, right? That seems like a reasonable concern right now based on all the headlines. So it seems like, political witch hunts and going after your political opponents by using, the apparatus of government is something that is becoming increasingly common even in the United States. And that is alarming. There is no choice, though. No choice. No freedom here. There's no choice. You have to rely on the hope that the government won't allow bad actors access to your sensitive data. So submit, trust, and hope. That is how you can assuage your data protection concerns. If you have data protection concerns, the government's advice to you is to submit, to trust, and to hope. And if you don't like that, don't be a beneficial owner of a company in the United States doing business in the United States. Remember, the implementation of the BOI reporting requirement is a huge, huge change. It may enhance transparency in the corporate sector, and the process almost certainly will seem daunting for many businesses. But proper understanding and preparation are key to ensuring compliance, and a lawyer can help you with that. So you should have one. This is just one more reason why you can't go without a lawyer if you're doing business in the United States. You just can't. This initiative is not just a regulatory requirement, but it's an aggressive step towards the Department of Treasury policing the U.S. financial system, and they do it in the interests of national security. They say against illicit activities. They say, but the practical effect is everybody loses privacy. Businesses are encouraged to start preparing now for this upcoming change and seek guidance as needed to navigate the new landscape. Um, I I'm here for you if you need help. I am a sort of novel guy when it comes to practicing law. I do things a little differently. Um, Not bad differently, but just differently. I hate the billable hour. I provide subscription based legal support to growth stage companies. And I basically provide a fractional chief legal officer service that saves companies an average of 87% over the cost of hiring in house counsel. So I've saved my clients millions and millions of dollars over the years. I love what I do. I love my clients. I work hard for them, and I put out information like this from time to time because I care about small businesses and growth stage companies, and I hate to see them burdened with huge regulatory compliance costs. So I'm here to help however I can. I really appreciate your time and attention. Thanks for watching, and stay tuned in to this channel or wherever you're watching this video for more updates like this in the future.